Hello and welcome to CGAP's webinar, Beyond Consent, Why New Approaches to Data Protection and Privacy Are Needed in the Digital Age. We're delighted to have two expert speakers with us today, David Medine. He is a senior financial sector specialist at CGAP, and David will talk about why the consumer consent model is broken and discuss some new approaches for how we could handle data protection today. And we're delighted to welcome Renuka Sane from New Delhi. She's the Associate Professor at the National Institute of Finance and Policy, who's conducted some exciting research that starkly illustrates how even the most educated cannot follow data privacy policies. But before we begin, I'd just like to go over a few logistics for this webinar. All of the attendees' microphones will remain muted throughout the session. When you want to ask questions, please would you use the chat box that's located to the right-hand side of your screen. You may submit a question any time during the webinar presentation, but to ensure that the moderator sees your question, do make sure that you select the All Participants from the drop-down menu when you're submitting that question. This webinar will be recorded and we'll email it to all of you who have registered. The agenda today will be David, who will then be followed by Renuka, and we will reserve about 20 minutes for questions and answers afterwards. So to begin, may I hand over to David?
Thanks very much, Stella, and welcome to participants. Asking for a person's permission or consent has been the cornerstone of privacy and data protection law and policy around the world for decades. The idea is that once someone has read a privacy notice, carefully considered their options, and provided consent or ticked a box saying, yes, I agree, it means that they fully understand what will happen with their information, and therefore are in control of how their data will be used and disclosed. Let's think about how this works in practice in our everyday lives. Take our phones. Just for example, Indians have between 5 and 207 apps on their phones, averaging about 51. Just for example, in the United States, the average is about 80. And each of these privacy notices also on average allows for sharing of information with 3 third parties. So as a result, in India, you are essentially agreeing to have 153 third parties get your data, in the US up to 240, and I think we find that almost nobody reads the privacy notices on their apps. And so while we are theoretically consenting to this massive amount of sharing of our personal information, we really don't know what's going on. And it's hard to keep up with all these privacy notices. And that's just your apps. We also, on our daily lives, go to websites which have privacy notices that permit certain uses and disclosure of information. Our homes now have more Internet of Things devices, our refrigerator, our toaster, our security systems. Automobiles are tracking us with privacy notices, but the problem is that nobody reads those notices. Recently, Deloitte conducted a survey of 2,000 consumers and found that 91% of the people consent to legal terms without reading them. Young people have an even lower rate in that study. Between younger people between 18 and 34, 97% agree to conditions without reading them. And if we were to read all those notices that we get on a daily basis, it would take 76 workdays to read through all the notices. So privacy is really putting an unfair burden on individuals to manage their use of their information. We have too many choices that we're provided on a daily basis. Often those choices are in legalese that are hard to understand. Renuka will talk about that later. And drafted to give companies the maximum possible use of your data. We have an additional challenge in the world that CGAP operates in, which is focusing on poor people in developing countries, where we have literacy challenges to reading privacy notices, people who aren't that familiar with the technology. We have smartphones where it would take probably hours to read through a several thousand word privacy notice on a small screen with very few characters. And language differences as well, where we have countries like India where there are countless numbers of languages, and yet the privacy policies are sometimes written in languages like English that no one can understand. But the question is, does that mean that consent doesn't have any role at all? And I think the answer to that is no. Consent doesn't work well when people aren't reading privacy notices with regard to how their information will be used, third-party disclosures, how long their information will be retained or kept by a provider, and what data security measures are in place to protect their data. But consent does work in other contexts, particularly in what information you're providing to a company when you're applying for a loan or engaging with them. You do know if you're providing your name, address, birth date, and things of that sort. What you just don't know is what's happening with your data after it leaves you and goes to the company. So given the shortcomings of the consent model, at CGAP we've been considering a beyond consent approach to data protection. And we are considering 3 different alternative approaches. These are non-exclusive approaches to how data can be protected in an environment where people aren't reading privacy notices or understanding them. The first is a legitimate purposes requirement that would be imposed on providers. What it would mean is that when someone collects your information, they can only use it for the purposes for which it was collected. And that way, when you give over your information, you expect it to be used to process your order, to fulfill your request, to ship it to you, if it's a product, to provide you the information you've requested. But the provider can't go beyond that use of the information. Another model is the fiduciary duty approach, which is basically the provider has to act in the customer's best interest and not use the data for their own self-interest, but in the interest of what the customer is seeking from them. And the third is a learned intermediary approach, where we get a third party who will evaluate and test the algorithms that are being used to make sure they aren't biased and they actually are accurately predicting what the customer wants, and also advises consumers about these complex privacy notices that are really in legalese and hard to understand. In addition to these burdens that would be put on the provider, consumers would also be given additional rights as well that would, maybe they would not have as much consent up front, but they'd get the rights where it really counted. So they have access and correction to their personal information, portability where they can shift their information from one provider to another, and the right to have their information deleted when they no longer want to deal with a particular company. So this discussion so far has dealt with what happens when people don't read privacy notices. Our next speaker, Renuka, will discuss some startling research about what happens when people do read their privacy notices. Thanks, Renuka.
Thank you, David, and good morning, everyone, or good evening, depending on where you are. I'll jump right into our research. Basically, as David mentioned, we at NIPFP, with my colleagues Smriti Parshira, Faiza Rahman, and Rishabh Bailey, set out to understand if disclosures in privacy policies are useful and whether consent works. And the objective of our research was to understand whether this method of consent is broken, and more importantly, can we make consent work? Could we move to the next slide, please? Can consent be made to work? And why is this important? Because in the debates around the world on how to design privacy policies, the role of consent is being questioned. Several people are saying that the consent model is entirely broken and we need to move away to something else. In India, too, we are having fierce debates on the structure of the data protection law. We don't have one. There is a draft data protection bill in the works, and consent has been central to that debate. And hence, we wanted to come in and ask if consent was broken, why was it broken, where was it broken, and could it be made to work? So how did we approach this? We said that we wanted to do 3 things. One, we wanted to evaluate how privacy policies are actually written. Then we wanted to evaluate whether users actually understand whatever it is they have of the privacy policies, and can this inform us about the role of consent. So we set about by studying the privacy policies of 5 online services. These were chosen because of their popularity of the different sectors, and we also tried to do a mix of online services that are foreign-owned, that is outside India, and online services that are homegrown. So we chose 5. One was WhatsApp, Google, Uber, These are foreign services and they are very popular in India, and I don't have to introduce these to most of you, I hope. The other two services are Indian companies. One is Flipkart, which is an e-commerce marketplace and is a rival to Amazon. And the final one is Paytm, which is India's leading payment gateway. And it was the first to reach over 100 million downloads by 2017. So these were our 5 services we chose, and we said we're going to study their privacy policies. Then the question in front of us was, how do we study their privacy policies? So we had 3 approaches. We said that we are going to study them from the point of view of access. How easy are they to find? How long are they? Are they in different languages that people in India speak and understand? And what is the quality of the readability of these privacy policies? That is, if they are in English or whatever language they're in, how easy are they to read? How complex is the structure of the sentences? How much education does one expect to have to be able to comprehend whatever is there in that policy? Then we said we'll study them from the point of view of visual presentation and from the point of view of substantial content. And I'll explain each of these as we go along. So if you look at the results on access and readability, we find that each policy is about 2 clicks away or 3 clicks away. Some of them are on the 1 click away, but most of them are slightly more than 1 click away. They range between 3 to 10 pages if you were to print them out, and between 800 to 3,000 words. So that's a lot of reading that one has to do before one signs up for any of these services. Interestingly, most of these policies are in English except for Google, and most Indians do not speak English, and yet they use these services, and the only way they could access the privacy policies was through a language that they wouldn't understand. And even in the quality of English that is used, when we compare it with readability tests, we find that the quality is, the way the policies are written is that they are very difficult, which implies that you need at least a college degree or a university degree to understand what is written in those policies. So you can imagine how hard it is to access what is written and what it is that you are signing up for. Moving on to visual presentation, we wanted to see whether policies are written in bold font, whether there are subsections, whether there are pop-ups when one moves the cursor, whether certain definitions are provided in an alternative page or an alternative way. And we find that there is a lot of variation in the way the visual presentation is done. So for example, Uber, Google, and WhatsApp, these are the 3 foreign companies that actually do have multiple sections in bold font. Google does have pop-ups whenever you move your cursor to different aspects of the privacy policy. There are click-throughs for more information, again, on the foreign companies. So when it comes to visual presentation, it's actually the foreign companies that do slightly better with these kinds of demarcation that make it easier to read. Of course, conditional upon the fact that you know English and you know college or university level English and have the patience to go through about 3,000 words. When it comes to terminology, what happens is that the terminology is extremely ambiguous. Next page, please. The terminology is extremely ambiguous, and you will constantly see sentences like those mentioned in the slide. So, for example, if I were to read one out, it would say, "We do not retain your messages in the ordinary course of providing our services to you." Now, nobody really knows what ordinary course is, and so it's not very clear what this sentence means. Or if you look at the third sentence, which says, "We may retain certain popular videos or photos on our servers to enable easy distribution." Now, what is a popular video or a photo? It's again extremely unclear. Or policies say that, they give you illustrative lists of the kinds of information they are collecting from you. And then this list is illustrative. It says it includes X, Y, Z, but then it does not tell you everything that is included and what is excluded. So basically, it's extremely difficult to find out what exactly the privacy policy is covering, what exactly is going to be retained and what is not going to be retained, even if you understood all the complex English that there was to understand. Moving on, we then start analyzing these privacy policies from the point of view of substantive content. Now, what do I mean by that? There are certain accepted principles that should be a part of any data protection law. The world over, the debate on what constitutes a good data protection law has sort of agreed upon some of these principles that are mentioned on this slide. The GDPR, for example, talks about the fact that you need to have some restrictions on what can be collected, some restrictions on what is the permitted use, some rules about how you can share things with third parties and with affiliated, what is the manner in which data will be shared with governments, should there be a data breach notification, what are the rules regarding accessing one's own data, what are the rules regarding data retention, that is how long can companies keep the data on their servers. Similarly, how easy should it be to allow users to seek clarifications on whatever it is that they are using, and again, data portability or exporting of data. So what we did was we said, let's analyze these privacy policies and see whether they even have, features that speak to these privacy principles, whether they talk about these principles, whether they have these provisions. And what we found is that, many of the policies are quite silent on some of these principles, and many of the policies are very ambiguous about some of these principles. So to give you a few examples, on the collection question, all 5 companies collect as much information as they possibly can. They are all using very broad terminology, and the terminology is ambiguous, as I had mentioned earlier. The third thing is that information sharing between a group of companies is fairly common. So when you are reading a WhatsApp privacy policy, for example, and it says that we might share information with our group companies. Now, WhatsApp is owned by Facebook, who owns 100 companies, I don't know how many companies, and maybe every day they are adding new companies to their list that you may not even know about. And it seems that, this kind of information will be easily shared because it's part of a group of companies. On the question of law enforcement agencies, all privacy policies say that we will share it with law enforcement agencies, but it's not very clear whether it will only share it with LEAs once proper procedure is followed by the LEA. So how easy is it for a government to pick up the phone and say, hey, Facebook, give me data about XYZ person? Will Facebook say yes, no, or will Facebook push back and say, we need to have the proper procedure before you can ask us for this data? Is not very clear. So I'm not sure what they do, but from the reading of the privacy policies, one is not very clear what the policy of the company is. Moving on substantive content again, all policies are fairly ambiguous about their data retention practices. One doesn't know how long the data is kept for. One does not know that even if you get out of that online service, for example, if you close the Uber account or if you decide to not use WhatsApp anymore, is your data permanently deleted or is it kept on the servers and retained in perpetuity? So this is extremely unclear when you read the privacy policies. On the question of ease of seeking clarifications, 4 policies do provide some contact details, but the other one does not. So it's not even clear that users can ask questions about what is happening to their data or seek clarifications about what certain aspects of this privacy policy may mean. So all in all, it does not look very good. Lots of things are ambiguous, lots of things are not mentioned at all. And that brings us to ask questions on whether users actually understand what it is that they are signing up to. So what we did to measure that was that we decided to survey students on college campuses around Delhi. And our target audience was that they should be educated, they should be able to read and understand English, they should have used some of these services. And of course, we wanted a mix of a law and a non-law background because we were going to make them read these privacy policies and then answer questions. So what we did is we walked into a college campus. We had a bunch of students and we randomly assigned them one of the privacy policies. So we had 5 companies. So in every college, we had a mix of people that were looking at the privacy policies, and we designed a quiz where we asked them, we made them read the policy and we asked them questions. So before I talk about the questions, let me describe the sample a little bit. We had a total of 155 respondents from people in the Delhi region. 33% of our sample came from a law background, while 67% came from mostly an economics background. 59% of those were postgrads, while 41% were undergrad students. So when we walked into these classrooms and we gave them the privacy policies, we found that respondents took between 10 to 20 minutes to actually read the privacy policy. Then they were given a quiz, and the quiz had 10 questions, and they were of three kinds: easy, intermediate, and difficult. So let me give you an example of what's an easy question. So it says, can Paytm automatically collect details about the model make of your computer? So this is an easy question because if you read the Paytm policy, it is given very clearly what Paytm says about this. So if you read it, you should get the answer to this question. And this is, the question for all 5 policies or 5 quizzes. The first question is always about collection in this manner. It's just that the name of the company will change. An example of a difficult question is the second one, where we say GemTM, which is a subsidiary of Paytm, provides a customized solution, and can Paytm provide this information to GemTM? So each question had 3 answers, which are yes, no, 4 answers: yes, no, policy does not specify, and can't say. So for example, if a student says the correct answer is policy does not specify, and the student says policy does not specify, then he gets 1 mark. So that means that the total marks, so if you got all the answers correct, you would get a score of 10. So we find that an overall average for these 155 students was about 5.3. And there wasn't much of a difference between the law students and the non-law students, or between the undergrads and the postgrads. Even when it comes to companies, we see that actually there isn't much of a variation in what is the score that people got. WhatsApp policy readers got the lowest scores, but Flipkart and WhatsApp seem to have the most number of things that were just not specified. So where the policy was silent about certain features, and therefore, while the right answer would have been policy does not specify, we found that our respondents got those answers wrong. So in some sense, it's, the glass is half full and half empty. You might think that depending on where your expectations were, 5.3 is a good score or a bad score. But on average, despite a mixture of easy and intermediate and difficult questions, despite the fact that these were college-educated kids who understood English very well, the average score was 5.3. And what is more interesting is that if you look at the number of respondents who got the questions correct by question type, and in this chart we have the easy, intermediate, and difficult questions, you find 2 things. One, the more difficult the question, the lower is the percentage of people who get the answers correct. However, what is disconcerting, if you will, is that even on the easy questions, we have a maximum of about 75-79% of those who got the question right. So if you look at question 1, it's a very easy question, and one would have expected that everybody got that answer because it was so simple. It was right there in the privacy policy, and one did not really have to infer anything because the answer was there. And because this was an open book exam, if you will, the policy was in front of you while you answered the quiz, one would have expected a better score on this question, but we did not get a very good score. So only about 60-70% of the respondents answered even the easy questions correctly. So what do we conclude out of this? So from a qualitative analysis or the legal analysis of privacy policies, we find that policies are actually not accessible. They are not available in local languages, and they are primarily written with a view to protect firms from liability claims. What's worse is that various rights like data breach notification or data retention, which are considered extremely important in the design of a modern privacy law, they just remain unspecified. So therefore, the user is left to infer what their view or what the online services view on these things is. There is no information on where the data will be processed, and that's important because when there are users that are outside the US, we don't even know what is happening to the data, where it is going, and who is processing it. The other important aspect is that there are several legal terms that are used in the policy, and someone who's from a non-law background is unlikely to know what these legal terms mean, and it's just assumed that everybody understands what this legal term means. So from a qualitative point of view, these policies are very badly drafted. They are verbose, and the English is hard, and even after that, they leave many things unspecified or ambiguous. So even people with the best English reading skills are not going to make sense of what these policies mean. And it's not surprising then that the kind of results that you get from the survey reflects the quality of the privacy policy. So there is a low score, an average low score, and even the easy questions do not get everybody being able to answer that question. What we also find is that there was a trade-off between the length of policy and user fatigue. So, and this is a challenge about how to do this well. Because on one hand, Google had the most specified policy. It had the lowest number of features that were left unspecified. But on the other hand, it was really, really long. So how do you do this? Because while you may specify everything, then the user may just get tired and may not want to read everything. So there is this tension, and I'm not sure what the right answer is. And of course, like I mentioned earlier, when things are left unspecified, people don't know how to interpret that. And people don't know whether the message is hidden actually in some other sentences, and whether it's their fault that they are not able to make sense of whether this is in the policy or not. And another interesting feature from the survey was, when I said legal terms are not specified, the big problem that we found was that terms like third party and affiliate don't mean anything to normal users. And the difference between third party and affiliate is not at all clear. So, when Flipkart says that I'll share it with third parties, but I will not share it with affiliates, or vice versa, it's not at all clear who is a third party and who is an affiliate. And so it becomes extremely difficult to interpret any clause that uses these kinds of words without knowing what these kinds of words mean. So, at the end, I'd like to conclude by saying that, if we need consent to work, we have a long way to go, both in terms of how we craft these policies and then how we write them such that users can actually understand what they are getting into. And thank you for listening, and I look forward to your questions.
Thank you very much, Renuka. For participants, we'd be delighted to address some of the questions you have. If you could just send them to all participants on the chat box, we'd be happy to respond. Let me start by asking Renuka a question, which is, what overall conclusions do you draw from your study about the viability of the consent model? You biased the study in a sense a good way by focusing on more educated people, both college and law students. You gave them plenty of time to look at the policies, and then they had a chance to look back at the policies to answer the questions, which even then, as you point out, they had a low ability to reflect what was in those policies. In the real world, we have a mix of people who are busy and are not necessarily spending a lot of time, so that would even suggest a lower rate of understanding of what's in the policies. What do you draw from all this?
I think that one of the things that one learns from this is that the way we structure consent today is unlikely to work in the future. And as we sort of download and use more and more apps, it's impossible to make sense of everything that is an offer and to make these choices on whether you want to use a particular service or not. So I think that what we need to worry about is, give users some choice, but at the back end, we need to have certain restrictions on what companies can and cannot do. And I think that goes to how we draft the privacy law and what are the kinds of principles that we will follow such that certain things are, absolutely not done. And so the things that we provide choice on, or where the user can consent to, are things that he can meaningfully understand and make that choice. The other thing that I'd like to point out is that, currently it's a binary, right? You either sign up and you say yes to everything, or you don't. And I think that is something that needs to change, because, maybe if that changed, then you would be offering perhaps a smaller choice set to, if both these things change, you would be offering a smaller choice set to users so that they could meaningfully comprehend what is it that they are signing up for.
Great, thank you very much. We have a question about a business that wants to explore alternatives to traditional credit scoring for smallholder farmers. And the approach that they're taking requires detailed sensing of customer behaviors, including live location tracking. And the question is, if, in this effort to better serve customers who lack a credit history, would business be meeting a fiduciary duty? And again, these are not laws, and so we don't have any precedents in court decisions on how to handle these, but I think there's a good argument that that would meet your fiduciary duty, because your duty is to your customer to do the best thing you can for them in terms of evaluating their credit history. And if these are people with little or no credit history, they might be foreclosed from the credit market. And so using alternative types of data actually gives an opportunity to bring them into the system and serve their interests. I mean, this is a situation where their interest and your interest coincide, and so that's why you're using their data. Now, that's not to say that one shouldn't consider whether the type of data being collected is unduly sensitive, if it may be used for inadvertently or purposely for unbiased decision-making. So I think you should still take a look at the types of data that are collected, but as long as it's being used for the benefit of the applicant, and again, to try to bring people into the system, which is an issue that we face at CGAP quite a bit around the world, is people who have not had formal financial relationships. We're looking for opportunities to bring them into the system, and so innovative uses of data can be very beneficial for those purposes. Renuka, did you want to add to that?
Yeah, so I just wanted to add, I think also, some of this, for example, when you use data in a particular manner and you see that it ends up discriminating some kind of people versus the others, I think that what you would worry about is the kinds of discrimination laws that exist within your jurisdiction to see if you are unfairly making decisions about something, that might come back to hurt you. So I think that as we use the data, because this is such new territory, we ourselves need to be mindful about what it is that the data is doing. So I think that was something that we would worry about.
Thanks. We have another question about the Personal Data Protection Bill that's been put forward in India as a result of the Sri Krishna Committee that I expect that we may see introduced into the legislature sometime in the coming weeks or months. And the question was whether that bill will suffice. I think what the bill does is provide an interesting perspective on the fiduciary duty prong that would allow, again, put the burden on the provider to make sure that the information was being used for the benefit of the consumer. The bill is currently drafted only really gives little guidance as to how that's supposed to be applied. I think it's a fair and reasonable standard, so I think that's something that would have to be fleshed out either in subsequent drafts of the bill or its interpretations. But I think it's a step in the direction of not putting the complete burden on the consumer. Again, for all the reasons we've stated before, that's a real challenge in terms of understanding, knowing what's happening with their data after it's been collected. And so putting the burden on the provider to use the data in a fair and reasonable manner, I think is certainly a very positive step. And again, it would be helpful as time goes forward to spell out a little more about what that means. But I'm wondering if you have thoughts about that as well.
Right. So, but if one looks at the literature on information fiduciaries in the US, which is where I think the draft PDP bill has borrowed some of this from, then there are certain problems with this concept as well. And people are asking whether this is enough in the case where the business model is the data itself, right? Or so in the case of a doctor-patient relationship where you expect a fiduciary duty, you expect that the doctor cannot provide the service until she actually gets the data. This may not be true in the case of online services where they need not have all your data to actually provide the service. So I think that there are complications in the concept of the data fiduciaries, and one is not clear whether this will suffice. Also, the concept of fiduciaries is a concept that has been used in Indian law, and one will have to look at how courts have interpreted this particular concept, and therefore how is it likely to get interpreted in the context of data protection or in the context of online services. And that's when we will really know whether this works or not. So I think it's still early days, and more thought needs to go into how it will actually operate on the ground, and a study of the history or the precedence of the concept of fiduciaries.
So the New York Times decided to cooperate and set up our webinar very nicely by yesterday publishing an article in which they surveyed 150 privacy policies and found that they were an incomprehensible disaster. Renuka, I don't know if you've had a chance to look at it, but that survey reflected a lot of the concerns that we had about the readability, understandability of privacy notices online, and I think reinforces in a very timely way that the privacy notices really aren't drafted to inform in many cases, but they're oftentimes rather designed to protect companies from liability and also give companies the greatest use possible of people's information without real restriction. Any further thoughts on that if you happen to have seen it?
No, so I agree. We've seen that privacy policies are drafted poorly. But I also want to add that, there is also a lack of education about or a lack of judgment about where this data can be used and how. So even if you placed a very well-drafted privacy policy in front of me, I think that we still have a lot of learning to do in terms of the kinds of trade-offs that should guide my choices. And I don't think that we know enough about how to even think about this to be able to make up our minds. So as a field, I think we have a long way to go. And some of it will just evolve as we use more and more of these policies and more practices of how the data actually uses or what kinds of harms happen come to light. So it's a work in progress for all of us.
One thing I should mention is the question comes up from time to time, do poor people care about privacy? And they have lots of financial concerns and demands on their lives, but at the same time, do they care about privacy? And I think the answer is yes. And I do it based on two things. One is we conducted a qualitative survey about a year and a half ago in India with two firms, Dahlberg and Dwara, to interview 50 poor Indians around the country and ask them about their views about privacy. And there was a very strong view expressed about how concerned they were, particularly with regard to financial privacy and their interaction with banks. And they wanted to make sure that the data that they provided the financial institution benefited the consumer and not just the bank. And so that they've indicated that. In addition, we have some ongoing survey work now in Kenya and India where there are suggestions as well that poor people seeking loans are very concerned about how the lender will use their data, with some indication that they might even be willing to pay more to have their data protected. And so we'll have further results from those surveys later in the year, but I think that across the board, both in Africa and India, what we're seeing is evidence that privacy is a concern of poor people, and therefore having legislation like India is proposing and other countries are considering to address those concerns is timely for both the well-off and the poor people in that country. Renuka, one just technical question. Sorry, you want to answer?
Can I add to that,
Please.
if I can? So, one thing that I want to say is that different societies are conservative in different ways, and of course, poor people will care about privacy on things that are considered, taboo or given the context that they live in. And so I think that we should not assume that poor people do not care about privacy, and especially where, for example, if you live in a society where women do not have the same freedoms that people in OECD countries may have, then what they are doing with their money, for example, is very important for them to keep private than perhaps in other societies. So I think that we do need to keep that in mind as well when we start asking whether poor people care about privacy or not.
We had just a technical question about how you conducted your survey. Was this done in face-to-face interviews? Did you do an online survey after people had a chance to read the privacy notices? Just basically, what was the methodology?
Yeah, so it was not an online survey. We walked into college campus. And basically we had students in a classroom, and we gave them the privacy policies, and we distributed the questionnaire. So they were all sitting in a classroom. They had all the time in the world to read the privacy policy and answer the quiz. But like I said, they took about 15 to 20 minutes or 10 to 20 minutes on an average to read the privacy policy and fill out our quiz. And as we walked into the classroom, we randomized who got what privacy policy. So in every college, basically, there was a mix of students and there was a mix of policies.
So something you touched on earlier, but would like to hear more about is whether it makes sense to have some of these privacies written in more plain language. You talked about how it was complex and legalistic in many of the policies that you reviewed. And the question is whether it would be better to have those policies rewritten in language that more people could understand, perhaps without a college or law school education. But I guess that going against that is the fact that even with those technical language words in them, you already have policies that range from 819 to 3,355 words. Presumably a plain language policy that was complete would even be longer, as it had to explain some of the terms that were used. So how do you see the trade-off between understandability and brevity in privacy notices?
Like I said, Google's policy is the clearest example of where you are actually being explained a lot of things, and then there is user fatigue. I think this question goes to the heart of how one can make consent work, and I feel that we really need to revisit our choice architecture, which is, how do you design what companies can do and cannot do with the data, such that a meaningful choice can be presented to the user. And until we get that right, whether you're always going to face this trade-off between very high, very long privacy policies that tell you everything, but then you get tired, versus very short privacy policies that don't tell you anything, so you don't know what you're signing up for. So I really think that the way to solve this is to solve the choice architecture problem. And I don't think that, at least to the best of my knowledge, there hasn't been a move forward in what the principles of design of this choice architecture will be.
Yeah, I think from our perspective, I would also add what is the role of a privacy notice? Is it to fully educate consumers? And I think the challenge we've seen in my part of the presentation is that people just aren't reading privacy notices at all. Sometimes 90 or close to 100% of people don't. Again, think about all the apps on your phone and whether anyone has ever read a privacy notice for an app. And I have to plead that I probably never have, other than in preparation for this call, to see that they're even there. And so is the privacy notice really designed to educate people? Certainly, perhaps. But it also is an accountability mechanism, which is a company is committing to certain data practices, data security procedures, and so forth, that they can then be held accountable for by enforcement authorities. And so I think there is a value to the privacy notice, and certainly the clearer the better, so that those who do choose to read it would understand it. But again, even without that understanding, I think it does serve an important purpose. In terms of privacy policies, Renuka, are there specific things that you think should be mentioned in those policies that you noticed? Sometimes these were absent, but data retention practices, contact information, more specific terminology. Would you legally mandate those as part of privacy notices?
Look, I think that what to mandate on those privacy notices depends upon what your choice architecture is, and what are the obligations that you are placing on these companies over and beyond what is there in the notice. So, I mean, what is there in the notice is a function of what are the things that the company absolutely cannot do, and what are the things that the company actually has some degree of freedom, where it can offer a choice to the customers on whether they want to part with more of their data to get a certain kind of service versus not. So I think that until we kind of agree on this choice architecture, it's difficult to make a claim on what should and should not be. But I also want to caution everyone by saying that we should not go to the other extreme, where we place too many obligations on data controllers to the extent that they are not able to innovate at all, or where we take choice completely away from the customer. If somebody wants to give out data and obtain a certain kind of service, then she should be free to do so, presumably, if she understands the trade-off well, and if this trade-off is presented to her. And I think that our challenge is to figure out how best that can be done, such that the person is actually able to understand what the trade-off is. And of course, if I may just add one more thing, a lot of this depends on the kinds of harms that we see that will happen once more and more of this data is circulated and we see how it comes back to bite us. So today it's difficult to foresee what is it that my data can be used for, and how can it be misused, and what are the costs to me from giving out this kind of a data. So I think that these kinds of implications need to be brought out more such that people can make a choice. So we need work from both ends. From one end, we need to have obligations on data controllers on what they absolutely cannot do. But on the other hand, we also need to have customers who are better educated to actually understand the trade-offs that might be involved in making certain choices.
Yeah, I think the poster child for what you're describing is the Facebook Cambridge Analytica situation, where people provided their information for social network purposes and didn't expect, and probably in many cases wouldn't approve of its use by a third party for election purposes, perhaps even in a different country. And so I think having a better understanding of the potential risks of data use down the stream is very helpful. We also have a question about the choice mechanism that you've been talking about. Right now, consumers really have a binary choice of yes, I will sign on for this service, and no in many cases, and sometimes don't have the fine-tuned choice of yes, but you can't use my data for location tracking, or you can't use my data for giving to third parties, or you can't store my data for a certain period of time. Can you elaborate a little bit more on the sort of non-binary choice that we're currently facing and what you would rather see instead?
So, for example, whether it is to, if you are buying a service and where you potentially don't require to give an address, or you potentially don't require to give your phone number, for example, then I think that there should be a spectrum of choices where you say, I'm not willing to give XYZ piece of information because that does not seem to be critical to providing this particular kind of a service, and so I don't want to give it and yet avail of the service. Or maybe I don't want to give it and I will avail a different kind of a service, but that kind of a choice should be there. Now, if you tell Uber that I don't want to give you my address, then it's hard for Uber to send me a cab. And so in that context, maybe address is critical information, but I could imagine that WhatsApp doesn't need to know, doesn't need to ask what my address is. It probably knows through location services anyway, but this is probably something that I can switch off because it's not important to actually give this piece of information out and yet avail the service. So I think that these are the kinds of choices that users should have in terms of what information they give out and what they keep to themselves and yet avail of the service.
And I think what you're describing fits in nicely with our legitimate purposes approach, which is that it's fine for the information to be collected for the purpose for which it was provided. And so in Uber's case, again, where you are at the moment is critical to having the driver know where to find you. But there have also been reports in the past of Uber's, I think, Angel View or some sort, where they basically could track their customers and know whether they had been having affairs or what doctor's appointments and things of that sort, and they were using it for purposes other than directing the car to your house or to wherever your location was to pick you up. And so clearly there's a line there, that clearly, it's almost laughable, but clearly wouldn't pass the legitimate purposes test in terms of why I provided my information to you, but information of that sort, I guess this is another example, could be misused if there weren't legal protections on how the information is used downstream.
It's true, and this makes me think about whether technology can itself be a solution for these kinds of problems that have arisen because of technology. And as we think about the data protection framework and the data protection debate, perhaps we should also think about technology-based solutions that can mask some of this data so that it cannot be again used against us.
I just wanted to just sort of, emphasize one of the findings in your report, which is really startling, which is that 20 to 40% of respondents missed the easy questions. What does that tell us about privacy notices? This is, again, a highly educated group of people who had all the time in the world. It was an open book exam, and yet even then, we have 20 to 40% missing the easy stuff. What does that tell us about the effectiveness of privacy notices?
It's hard to know the exact mechanism of why is it that they missed this kind of easy stuff. It's possible that they were bored and they just wanted to get out of the class as soon as possible, and they didn't actually read it because, beyond a point, we can't force people to read it. I think that because they were students, we still got a pretty good response. Like you mentioned earlier, in the real world, people may not even spend enough time to actually read. So I think it's a mixture of both these. One is interest in reading, and the second is that, maybe it is difficult. While it might seem easy to us and while the answer is right there, perhaps the language is still kind of complicated, or people are confused about what certain phrases mean, that they are not able to answer the question. So I worry about that, but at the same time, given that the world is becoming so complex, we will have to place some burden on the users as well. It can't be a world where all obligations are placed on the data controllers. So we'll, eventually evolve to a place where customers do have to take some interest and pay some price if they are to use some of these services. The question is that a price that is reasonable for them to pay, or is that a burden that is reasonable for them to bear before they actually use the service?
And I guess the last question is, did you get any feedback from the participants in your survey about their experience, the college and law students, about what they thought about having read these policies and the process that they went through?
Not particularly. I think some of them just walked out saying, actually I'm not sure what they felt about whether this was easy or difficult. So I'm not sure what they truly felt. So we got them to answer these questions, but ex post, we did not really do focus group discussions with them about the experience of filling the survey. But this is something that we could potentially do the next time we take this survey forward.
Thank you very much, Renuka, and thank you to you, David, for some great insights and some really interesting findings. You can access the study that Renuka conducted. We will be emailing you not only a link to her study, but also a link to a recording of this webinar after the event. We also do encourage you to stay in touch with CGAP, sign up for our newsletter, and we will inform you about future webinars. Thank you, everybody, for participating. We enjoyed having you.
Thank you, everyone.
Thanks. Bye-bye.
Thanks. Bye.